Thank you. Anybody else up in Carson City?
Hi, Eric Edgerton here. Just wanted to comment on a few points I've heard over the last hour. I like Kelly's comment in regards to sanitation standards across the board being at a FDA standard or level. And looking here on line 68, paragraph 3, with agents from the dispensary having direct contact with the medical marijuana. As a patient, my concern is the handling of the product. Is it possible for the laboratory to do all packaging? So as a patient, as I get the product, it's in a tamper-resistant container. It's sealed. Last time it was exposed was at the laboratory. And with the technologies of nitrogen purging, it can help this perishable product extend its shelf life. I think that would be a great benefit to the patients of Nevada. I appreciate RJ coming in from Arizona and giving us some input. A lot of these states that are ahead of us are having growing pains. It's an evolving industry, and we need to not exactly replicate other states, but maybe go a step further. On the point of education for employees of these facilities, maybe it could be implemented to have some type of continuing education units to renew your permit, state how you're educating your employees and making it more clear. That's all. Thank you.
Thank you. Anybody else in Carson City?
Shane Johnson once again. Just one comment with regards to packaging. I'm fully supportive of packaging being in a clean and controlled environment, unless the state's ideas of a laboratory are different than mine. Though I think it would be very difficult to have the laboratory potentially package everything in the quantities that we're talking about. So, to the extent that the laboratory is just testing to make sure that a given lot is, safe and meets the standards, I think is very appropriate. But to me, that would be randomly selecting from packaging that has already perhaps been done at the cultivation center or the, establishment that's manufacturing medical edibles or other types of products. So I just think we should be careful about who's taking on what burdens and responsibilities and making sure that everything does happen for the patient's benefit at the end of the day. Thank you.
Thank you.
Marla?
Anybody else in Carson City?
No others.
Yes. Okay, let's go to the phone. Please remember to identify yourself and be make sure that you're muting once you're done and as you continue to weigh in. So go to the phone.
Hello, good morning. My name is Benny Tuzon. I'm from Las Vegas. And my background is physical therapy, occupational therapy, as well as respiratory therapy. When we had our clinics back a couple years, the Division of Health required our establishment to have a medical director. And it is a great idea. And for the purposes of us rehabilitating our patients, the doctor needed to either be present or to sign off on all the physical activities they were doing. However, as far as a dispensary is concerned, my opinion, I feel the medical director or a consulting physician should not have a place in the dispensary. And the reason being is because as far as a doctor recommending the medicine, the medical marijuana itself, I think that's as far as their participation can go. Just like in any pharmacy or any medicine setting. They would prescribe a medicine, and that would be it. If there needs to be further consulting after that, a simple phone call should suffice. Therefore, I believe that a medical director inside of a dispensary, I wouldn't want to say it's a complete waste of time, but it's just not as necessary as I believe it to be. Thank you.
Thank you. Next caller.
Yes, this is Max Del Real Marla. Thank you to you and your staff for taking time to put this important workshop together. I work as a lobbyist and consultant for the medical marijuana industry throughout the West Coast and even on the East Coast. I was very honored to work closely with Senator Tick Segerblum and Senator Mark Hutchinson on this important bill. My comments today will be brief, but I'd like to focus specifically on line 72 on the summary page, talking about the responsibilities of the dispensary. I think it's important to note at this particular time in the development of SB 374 and the application process for medical marijuana establishments in Nevada, I think it's important to note that there are effective and valuable models that exist today in Colorado, in Washington, in California, in Arizona. Nevada now is the 21st state in America that has medical marijuana regulations in place. My comment is not a question, but rather a comment, is focused on the importance of three things in the application process, specifically a business plan, a security plan, and a community outreach plan as well. These components, all three, have been used by a number of other states talking about the value and really the expertise of the applicant. And I do want to focus my comments specifically on the issue of the applicant himself or herself. The Nevada legislature took up the issue of whether or not Nevada would require or mandate Nevada residents to be the sole applicants for this program. The Nevada legislature said no to that fact. They did say yes to Nevada-based businesses being a part of the application process, but I think it's important to note that there are a number of highly successful dispensary operators that have multiple years experience managing these businesses, and I think it's important to recognize experience in the application process, and when we get to the actual application itself, that the applicant have a Nevada-based business, but not necessarily be a full-time Nevada resident. I appreciate the opportunity to participate.
Thank you, Mr. Del Real. Next caller.
Hello. Hi, this is Chris Francie from Clark County, Nevada. I just want to follow up on what was just said. And while that could be given some thought that, that would be meritable for the application process, having experience, I don't think that it should be mandatory or given too much weight, because it's not fair to people here living in Nevada who haven't had an opportunity to participate in this business up until now. So that's all I want to say.
Thank you. Next caller.
Carol Hall, Nevada. Can you tell me what has been determined as far as the application requirements? When will the application be available for us to send in? And what other types of concerns do you have in the application? if you have 1,000 applications and there's 10 dispensaries in Reno, Nevada, how do you determine who gets what?
That's the $1,000,000 question. Our session tomorrow is designed to have the discussion about the applications, and we may not even have answers to those questions tomorrow. The best we can do is lay out what we're looking at that helps us weigh applicants. But I would like to not go into the application process and selection of dispensaries today, but to save that for tomorrow if that's okay.
Thank you.
Can we go to the next caller on the line, please? Is there anybody else wanting to comment on the phone?
Yes, I do. My name is Michael Levinson. Hello?
Go ahead.
Hello. Yes, thank you, ma'am. I had a question that's really a clarification as to line 63 about where a dispensary... I don't think that's my phone. Hello?
Yes, you're still there. Go ahead.
Thank you, ma'am. As to line 63, as to where cannabis can be obtained by a dispensary, it says, quote, another facility, end quote, presumably another licensed medical marijuana facility. But what I recall from last week's discussion was there would be, or is there going to be, any rule against the other facility being owned by the same individual or group of individuals?
At this time, I don't envision us saying you couldn't buy, if you had more than one dispensary, you couldn't buy from yourself. I don't see these rules addressing that issue. Is that what your question?
Yeah, essentially, could one individual or group of individuals own more than one facility, produce it, meaning grow it, process it even, and then dispense it? Although they'd have to have separate licenses, I understand, for each of those activities, it does not seem to preclude, and apparently what you're saying is there is no preclusion against all of those three activities being done by the same individual or group of individuals, essentially one company with three licenses doing all three things, even potentially at the same place. Is that correct?
That is correct. These regulations will not prohibit those arrangements. The only thing that we're prohibiting is ownership in the lab.
Understood. Can you say, it may be very difficult to say, can you say whether there would be, for lack of a better word, a bias or some sort of inclination against one group doing all three, or is that really not necessarily anticipated?
I don't think that, again, the rules will not disadvantage anyone or give someone an advantage if they came in and wanted to own more than one type of establishment. But, the reality is, and again, this is a conversation for tomorrow,
okay.
Depending on how we solicit applications, that model may not work. It just may not be an approved application. So
I see. Okay, I'm sorry to interrupt you, but thank you. I did have one other comment and perhaps a question at the same time, which is I'm an attorney in California, and I have handled many, many medical marijuana cases. And one of the things that I've noticed is in reading through the statute, the Nevada statute, it seems like essentially many of the problems that have arisen in California were sort of read and understood and almost directly avoided by the Nevada statute. So, there are people in other states that have experience that can relate to essentially how good this law can be. And one other thing I was going to mention is that there really are software tracking systems that are very good for tracking from seed to sale. Do you anticipate that the state will essentially authorize one that will be the one that will be expected to be used, or do you have no decision has been made along those lines?
Thank you for that comment, and I guess I'll just start by saying I think some of the pitfalls that other states have experienced and, us trying to avoid are the credit of people like Assemblyman Horn and Senator Segerbloom, who made great effort to try to ensure that we were able to move this forward and in a very professional manner. So I'll just give them credit for that. As it relates to the software tracking systems, I think that's a question that we would pose to you. From a logistical perspective, if we as the state agency said, we're going to tell you which software system to use, I believe we would have to go through a public bidding process. And if we did that, that just adds to the time in which we'd actually be ready to move forward with any applications. So at this point, I don't think it's something that is on the table unless there's enough of you all saying that that's absolutely the only way that this can be managed. I think other states have allowed the dispensaries to get their own systems, and what we intend to do is to lay out the parameters for those systems, to lay out the minimum requirements that have to be met by your seed to sale system, and then as we approve your applications and regulate you, to ensure that you're adhering to those systems. That's the way that we intend to do this, unless there's, again, enough public pressure that you want us to do it. And again, if we do it, it will extend the timeline. And that's not a reason not to, if that's the best way to do it. I believe Colorado, I had heard that Colorado was actually moving down that path now, but it came after they had already moved forward. So I think it's something for us to consider out in the future, not in this regulation set right now.
Thank you.
Any other commenters on the phone?
Yes, hi. I'm sorry, go ahead.
No, go ahead.
Thank you. My name is Lakeisha Baker, California, owner and operator. I just wanted to know, I know how California has done things. So from a city and state level, everything is okay. You have your business, you've been authorized to open it, and then there's the federal angle where they begin to send out letters to shut down. Has that been looked at, and how that will work, and if that happens, what the next recourse would be, kind of a thing?
I'm sorry, I'm not understanding the question.
Okay, so in California, you go to your city finance office, you let them know I'm opening up a dispensary. They've authorized it because that city is on board with it. You open up, you have all of your paperwork, everything's in order, you're incorporating paperwork, everything is all done through an attorney. Then you open, and federally it's still not legal. Therefore, someone from the U.S. Attorney's Office sends your dispensary a letter that you need to close, basically. That's what was happening in California. I can't speak to other states, but that's what was happening in California and here. So my question to you in Las Vegas, your dispensary opens, would your federal department then send the dispensary a letter to close? Is that something that's been, someone mentioned earlier that the federal part of it needs to get on board. So that's I'm kind of in that same area of her question from about an hour ago.
So this is Marla. We are a state agency, and as the state agency, we are implementing the state law that was put in front of us to implement. So I can't speak to what the federal government or any of the enforcement agencies would do at this time.
Okay. Thank you.
Thank you.
Good morning. This is Steve Cottrell from Arizona. To let the lady know, previous to this conversation, this is a federally illegal substance. This is a gamble. So the federal government can come into any one of our doors that is on the line at any time and completely violate us because this is a federally illegal substance. So
I'm aware we struggle with it daily. I just wondered if anything at all had changed.
This is the gamble that we take. Sadly, the federal government has said that they're not going to be messing with anybody that's completely, everybody that is completely abiding by state regulations and state rules. However, we know the government doesn't lie.
Yeah, I've noticed that those that are paying their taxes and are paying their quarterly sales and use tax are those that are not bothered.
Okay, if we could move on, is there another question from any callers on the line?
Las Vegas, Nevada.
I'm sorry, your name again, please?
I just had a quick question in regards to, and I'm sorry if this is a redundant question that's already been answered, but in regard to dispensaries opening for the first time, how are they to acquire product to sell to dispensaries or to patients? Are we going to have a system where we roll out processors first or manufacturers first, and then dispensaries will open 3 months down the road once they can have a first grow under their belts? Or how is that process? Are we going to be able to purchase from California, or how will that roll out?
This regulation set will not speak to acquiring the product. We do intend to license cultivators and labs or to certify the cultivators and labs as the first group of establishments, so that there is product available for dispensaries. So that's as much as I can tell you at this point.
Okay, and then one more question in regard to applications, and this may be, again, a question for tomorrow, and I apologize if that's the case, but if someone applies for, say, 3 licenses, can one be denied? Is one application going to be denied if something doesn't fit, or can something be changed as far as, we feel you have too much square footage and you'll own too large a percentage of the market? Or will the whole application be denied because you're applying for, I'm just using a really odd number, but if someone applied for a 100,000 square foot warehouse, and that would obviously be too much because they don't too large of a percentage of the market, can that person then be qualified for a 20,000 or 15,000 or 10,000 square foot facility, just not a 100,000 square foot, or will that be denied completely?
Okay, yeah, I think that is a question for tomorrow. The way that we're going to, propose is that there would be an initial review process and then an application process. So I think there's an opportunity to work with people, but it really, it depends on how tomorrow works out and whether or not people are agreeing to the proposal that's been laid out. As who moves forward down the process. So I don't have good questions for you. I think, though, there is, we do need to consider if you're going to tie your application to 3 different facility types and one of those isn't going to meet any of the criteria, does that reject the entire 3 application, or not? So, and right now, I don't think we've addressed that, but I think it's important enough for you all as an industry to really weigh in and have that clear. When we do have that discussion tomorrow. If we could go to the next caller on the phone and please make sure to mute your line if you're not calling. I'm sorry, please identify yourself again.
I'll tell you what I'll avert here in a minute. All right. I'm just going to keep listening to this while you drive. Okay.
Michael Augustine, County, Nevada.
Your name again, please?
Hello? Nye County, Nevada. Your name again?
Yeah, I heard Nye County. We do have someone on the line who's driving and listening. You need to mute your line.
To sleep for the winter.
Whoever's talking on the line, please mute your line.
Yeah.
Okay, go ahead in Nye County.
Thank you, Marla. Wanted Michael Augustine, Nye County. Muted?
Yes, go ahead, Michael.
Yes. Michael Augustine, Nye County. Muted? I'd like to sound in on a couple of items after listening Friday, and the dispensaries being the second, allowing the cultivation and labs to apply and give them, allow them first is going to kind of, there's going to be low interest because anybody that's going to be cultivating or in the labs are not going to have an idea what their draw is going to be. I know Las Vegas, having put the 6-month moratorium on it, it says, oh, okay, everybody's crunched up. Nye County in this rural area we have zero access to anything. Excuse me, I don't know if this is coming through. I'm watching it live, and the video conference is complicated because there's a lot of people trying to talk. So I don't know if I'm still here even talking to you. But the dispensary application, that's the I don't mean to call it a prize, but that's going to be the motivation for cultivation. Nye County, based on my experience with the symposiums and some of the actions that had taken place in Las Vegas, the interest is generally geared towards the rural communities. Nye County is 10 years behind, even catching up with the 13 years ago when we first allowed it. It's an area, we don't even have access to a medical doctor that will give a recommendation here. But without the drive of who's going to have a dispensary, without the bragging rights, if you will, because we made a for-profit. The drive for profit is going to generate demand. We know that it's exponential on what that demand is going to be. The fact that we're allowing reciprocity is driving. I don't have the money to do it. I've been in Nevada since 1966, specifically in Pahrump, and we've always been behind the times. We've always had trouble catching up with the rush, even the booms. There's people that come out here. There's big money people. I know because I've interviewed with them and have been rejected by these potential investors. And they're coming from Arizona and California and areas that have already established, and they have the knowledge. I know that this is going to be I believe Nevada is going to be the breakthrough to the end of this prohibition, this shameless. I'm so emotional because Saturday night at 2 a.m., I'm a med patient, and I grow my own based on the state laws, and I have stuck to them. I had my front door bashed in, and automatic weapons stuck to my forehead by Nye County Sheriff's Office, and they stuck my face in my carpet.
I'm sorry.
And
Mr. Augustine.
Without education with the sheriffs first and law enforcement, and what happened to me Saturday night, I cannot believe the timing of it. I have been nothing but involved, and I've been involved. I know you know my name, Marla. I've sent numerous and had responses back from you. The first thing that has to be done is law enforcement needs to settle down with the state and either the first, you know what they said? Oh, it's a shame you guys don't have a registry. We'd have known you were illegal. They went through, woke up the judge at midnight to sign a search warrant for my house because my one plant outdoors, somebody drove by and smelled it. And I am on a property.
Mr. Augustine, I'm sorry. Mr. Augustine. Mr. Augustine.
Okay,
please,
back to point.
Mr.
I'm sorry. I'm sorry but that needed to be out in the open because I am an activist for it.
We appreciate it. We know you have things to say,
should not have a doctor retained. It's a waste of money. The dispensary and the med patients that are going to be dispensing to the other med patients know what's best. We know how to treat and serve each other. First, dispensaries should go first. We need to know where the drive is going to be. The money is there for the cultivation. There are people in line waiting for it, but they're not going to commit. And so they leave people that are interested, that are patients. We only have 180 patients in Nye County, yet we have to service the third largest county in the United States with one dispensary. From Tonopah to Pahrump is 210 miles. From North Nye County to South Nye County is almost 400 miles.
I appreciate what you said, and I've heard what you've said. You want dispensaries to go first, and so this is all helpful information. Did you have any other specific points you want to make about our discussion today? We would like
the
to move on. We have other callers.
I would say his name, but he made a good point. The State Board of Cosmetology has an excellent, on truly the same level. If we were to look at their model on how they disperse inspections and on the sanitary, definite sanitary, I believe in that. But their model and their inspection methods with the amount of workload that it puts on the state for inspections is a good model to use.
Okay. Anything else?
I'm so sorry that happened. I've been preparing for my opportunity to share, and rural access. A doctor's register. Why not let the doctors tell us that they are interested in servicing med patients? In order for a disabled vet to leave Pahrump to go in to see Dr. Reefer for $700, that's insanity. To get a med card and go through the process, it's so hard they don't do it. They can't do it. Access in this rural community and the rural communities that are going to have limited dispensaries access need to have special attention.
Okay, we're about 2 hours in, actually 2.5 hours in. I think there are some people who may want to come back and have some additional discussion. So, Mr. Augustine, if you don't mind, we would like to go to another speaker.
Yes, ma'am.
Marla, this is out of nowhere. I'm a supporter of the bill. One of the things that we would like to see is a really more definition on reciprocity of the patients getting the card, more like the 3-day turnaround or 2-day turnaround. The turnaround seems like getting the card process is just too long. I know that we've adjusted that, but we might want to look at other states and how they're doing that based on that. If there is going to be reciprocity, how long is it going to take for a patient to get on board and get a card? They're not going to wait over a week. They usually here on vacation for 3 to 5 days. So that would be a suggestion to take a look at. Thank you. Thank you for your time.
Thank you. Next caller, please.
Hello, go ahead. This is Mike Betts in Las Vegas. I just wanted to touch on some of the security, if any armed security will be allowed or disallowed, or if it'll allow to be contracted out to third-party security vendors, so possibly they could be armed. Mainly for the cultivations, not so much the dispensaries, but it could pertain to all of them, to be honest.
I didn't understand the last part of your question. I think the regulations require security. They don't specify or get into whether or not they be armed or not armed, or that they have to be an outside. But again, they will depend on the dispensary to tell us what is your plan for security, and that we have to, and that there be some certain minimum requirements, and that we would have to approve that plan, and then you would have to adhere to that plan after your application was approved.
Understood. More so just pertaining to I feel the armed part should be addressed at some point, just because of the legalities behind it and things like that.
You want to require them to be armed or not require them to be armed? Okay, let's go on to the next caller.
Yeah. This is Earl Pelletier from Las Vegas and California. Touching on that last point, there is a sensitive item or a sensitive topic with having weapons in the same facility as the medical marijuana. I'm sure that's going to be a federal issue to whoever the licensed weapons carrier is. Also, there was something in the beginning of the meeting that there was. I don't have the bill. I don't have the new handout in front of me, but someone had mentioned that they're looking at imposing a limit onto how much a dispensary can actually sell per day, and I'm hoping that was incorrect, because that if it was a non-for-profit issue, like how the state of California, and they could set limits. But if it's for profit, and the state is the one that's going to be receiving the taxes on it, then they shouldn't impose any type of limitation. It's like setting a limitation on a pharmacy, how many pills they can actually sell, how much medication they can sell. So I'm hoping that point was inaccurate or incorrect when I first heard it when we came on.
Yeah, and if you could still answer the question, so we want to prohibit security from carrying weapons? Is that what you're saying?
Well, there's two areas. I mean, for a cultivation center, of course, you're going to protect your facility and protect your product, and also at the dispensary. In California here, we have situations where the facilities are robbed because the security is not armed, whether it be an after-hours armed service or during operating hours. That really needs to be addressed. I would actually approve having an armed service after hours to protect the facility, but during operating hours, I'm not sure.
Okay, let me address your the other issue you brought up. The limit would not be on how much product a dispensary could sell at any given time. The limit that we're required to lay out is what a patient can buy in a 14-day period. So they're two different things. Let's go to the next caller, please. Anyone else on the phone that wants to comment?
Yes, I did have one more question and perhaps a comment. This is again Michael Levinson from California. One of the problems potentially with armed security in California is that everyone who works in a facility has to be a medical cannabis patient here. And so there's some concern about medical cannabis patients themselves being armed unless they hire some sort of outside private security. And my question would be in Nevada, whether it's intended that there's any specific form of business structure that is either allowed or not allowed. For example, in California, they must be collectives or cooperatives, and they can't be operated for profit. Now, the profit issue is obviously taken care of in Nevada, but is there any specific form of business or not that's allowed? I heard reference last week to collectives, but it may have been in another context, and I may have misunderstood.
Yeah, there is no limitation on the type of business model.
Thank you.
Next caller, please. Anybody else on the phone? If not, I'd like to go to round 2 down here in Las Vegas, and remember to mute your phones, and if you need to take another call, to disconnect. Down here in Las Vegas, go ahead.
Yes, my name is Forrest Darby. I wasn't planning to testify on this issue, but a couple of out-of-state callers called in and talked about the situation of being an out-of-state operator and so forth, and wanting to come in here. As everyone that's lived in Las Vegas or in Nevada for a long time knows, Tick Segerblum has been the driving force for this legislation for a very long time. And at the big symposium here with all the out-of-state operators and all the heavy players, including Steve D'Angelo, Tick got up at the podium, and at that symposium, he said, "Don't plan to come to Nevada, I'm talking to you out-of-state operators, unless you have a Nevada partner." So just a message from what Tick said. Thank you.
Thank you. Please mute your phone. We can hear some paper shuffling or something. If you could please mute your phone. Go ahead, please.
Hi, Kay Swanger again. And I just have a couple of questions on some of the language in the suggested conceptual language section. There's reference in the bill and in this document to a medical marijuana establishment. And I'd like to know the thought process, excuse me, because to me, there are 4 different types of establishments: a dispensary, a lab, a kitchen, a cultivator. And for example, on line 7, subsection 11, there's an expectation of 5 different sets of policies and procedures. There isn't really any clarification to say that that applies to a dispensary, but it would seem like it does apply to a dispensary because it says that you need to have verification system, a patient record keeping system, and patient education support systems. And those items would not necessarily apply to a kitchen or a cultivator or to a lab. So there might be an opportunity to have more clarification when you reference a medical marijuana establishment, whether or not you're referring to all 4 or maybe just one type.
Where we listed in our proposal, it is to all 4 types. So if you believe that something is not applicable to a certain type, if you could weigh in specifically through email or that you don't think it applies to that certain, where it's that very general term, it would apply to all 4.
Okay.
Where it applied to something specifically, we tried to say that it applied specifically to that type of establishment.
Okay. I noticed then in line item 9, item 18, that there are specific expectations of a floor plan where we have to identify each room and its function, plus a sink, a toilet room, the means of egress, a video camera, a panic button, and the location of all of the lighting sources. So some of those items, maybe like the sink and the toilet and the egress, to me might be covered by standard building codes, because each one of these establishments would probably have slightly different building codes because of the service that they will be providing. And I'm just curious as to whether or not that specificness is applicable for this language, or if the building codes would simply take care of what you're looking for. And then I was curious about the purpose of a panic button. And I haven't read all 87 pages, but do you expect every facility to have a panic button, and who should we be panicking to? Our local security supplier, or directly to the police that are in the county or the jurisdiction that we're operating in? And again, there may be more clarification later on in the other pages, but I hadn't found it yet.
So let me get to your issue about building codes. I think you make a great point. If it is covered, then we shouldn't duplicate it. The challenge is knowing what level of coverage there is. And I think the requirement that you work through the local governments is maybe enough that we don't need to make those references. So I just ask you all to weigh in specifically if you think that it is redundant and not necessary for this regulation set to say so.
Great.
Regarding the panic button, again, we modeled after Arizona. It's their language. So if that's not something that's going to provide value, then we want to know that from you, that it does not provide value.
Okay. Then I also noticed on line 10, way over on page 7, that you are also expecting in the renewal phase a copy of the annual financial statements that have been independently certified by a public accountant. And is any insight as to what you're looking for in those statements? Just maybe validation that we've paid the taxes that are due, or are you looking for other things?
We have a session tomorrow that talks more about the financial aspect, and I think that we want to get into some of those details then.
Okay. I think that was it. Thank you.
You. Go ahead.
Michael McAuliffe, Clark County. I'd like to start off by saying thank you. I know that for many state employees, this is really terra incognita, the undiscovered country for you guys. I can say that having been involved with this for 12 years, the tenor of the conversation is so much different this year than it was a dozen years ago, or even 2 years ago in the legislature. And we in the community sincerely appreciate this change of heart and this evolution of thought on this very important issue. So thanks for the hard work you're doing. It's really important. To hit several points that I see here, we'll go back to line 10 and the renewal process, and subsection D talks about the name and license number of the physician who is consulting for the establishment. And this is an issue that I think bears further clarification, because the on the federal level, when the federal government comes into a facility and they have a physician who is working on site or is closely working with the dispensary, they say that physician is funneling patients into that business and funneling patients into this area of treatment that might not otherwise need it because they have an economic reason to do so. I think that here in Las Vegas, where we have a number of doctors who are specializing in this area, they would likely, most of them, be happy to sign on with a dispensary or two. And is there going to be a limit of how many facilities an individual doctor can deal with? Now, looking at the state documents, we see there are well over 400 physicians statewide who have made recommendations, but I worry if this is a requirement that in some of the rural counties where there's only going to be one dispensary and where there's very small populations, whether they're going to be able to find a local doctor. Over the years, I've had patients call me from most parts of the state who have had great difficulty in their local counties. So we want to be very careful here that we don't place an undue burden both on the patient and on the business owner here to have to tie themselves and hire a physician that will that they may not find locally, and if they have to fly somebody in or otherwise engage out of county sources, that's only going to drive prices up for the patients. As far as physicians recommending specific strains, okay, this is medicine. That kind of makes sense on one level. But in order to do that effectively, then I think there's going to have to be a mandate of a whole new level of physician training because there's certainly a huge field of medicine out there and people specialize. But even with that, the majority of doctors that I've spoken with over the years, they may know the difference between sativa and indica, but they're not going to be familiar with what reduces inflammation, which strain is better for anti-nausea, which strain is better for anti-anxiety, and so forth. So I think that we discussed on Friday the idea of having training requirements for people working in these dispensaries or anywhere related to this business, and that's a good thing. If you're going to have physicians do this, we need to mandate specialized training, or we might decide that it's better to just have the physician make a general recommendation. It's in the field of psychiatry with serotonin inhibitors and the like. Physicians will say, well, try this for a couple of months. Okay, that doesn't work. Try another one, try another one, try another one. So, with these pharmaceuticals, a lot of times they're guessing, best guess of which is going to work. So perhaps we might want to have experts who in this field be the ones who are making that determination or those suggestions. Because also the more that the physician does as far as recommending very specifics, unfortunately, the greater risk that puts them in the light of the federal government, and we do want to avoid that because we want to encourage physicians to take part in this, not to shun it. Moving on to another topic that was spoken about this morning, in-state versus out-of-state investment. We're all very concerned that this industry does not develop the way that the casino and the mining industries have developed in this state, that you have both of these industries making a tremendous amount of money in the state of Nevada and then taking it out for offshore ventures and removing that money that was generated here and paid low taxes on to be funneled out of the state. This poor state in the desert doesn't make a whole lot on its own, and aside from our gold, we don't have a lot of natural resource, so we've always been relying on bringing money in. So it's a real conundrum here of whether we want to allow this out-of-state money to come here and invest in Nevada, or whether we really want to keep this money as local as possible, generate as many dollars in the state economy as we possibly can, and keep that money circulating here. I can tell you that last year I went to the Democratic State Convention Platform Committee meeting, and in 2010 I had a floor fight to get a medical cannabis plank, industry plank, into the platform, and I was expecting the same fight last year, but what wound up happening was when I got there, not only was the plank already in, but it had been added to, and the reports were coming back, and this is not just a Democratic issue, because I hear this from my Republican friends as well. The reports are coming back that people across the state, in every county, were asking three things of this program. They wanted easier and better access to medicine and the program. They wanted dispensaries around, and they wanted the ability of typical middle-class, everyday Nevadans to take part of this new green rush, this new billion-dollar industry that we're having in the state. And so I understand that we could not preclude out-of-state investment, but I would hope that we can really exhibit a strong preference for Nevadans to operate this themselves. I understand that there's a lot of expertise in other areas, but so there is in Nevada as well. And to take that point a little bit further of Nevadans being involved in this. One thing that I've been hearing in back-channel discussions is that it will be easier for the state to regulate if there are fewer owners. For example, there are 40 dispensary licenses in Clark County with a potential 4 dispensaries per owner. And the idea is that there are going to be so many applications, it will be simpler for the department and on the county level as well to have fewer owners there, and also a larger corporate structure could be seen as being a more reliable player and not having diversion, that sort of thing. I worry that this is not in the best interest of patients, because anytime, if we have 40 dispensaries down here and we only have 10 or 12 owners, anytime you have a small enough ownership ring that you can fit them all into a stretch limo, I think there's the risk of, even if it's not active collusion, there will be price support levels there. And as I said on Friday, really what we want to focus on is the patients and the patient need, and that means more competition, lowering the cost of medicine to them. I think the dispensary owners and the cultivators are going to make plenty of money in this area. At our last symposium, Tick came right out to the crowd and said, we want you guys to make a lot of money, but we want you to do it the right way. And so in doing that, we want to make sure that the patients also get taken care of in this vibrant industry. So I would suggest, as I have done here in county meetings, that we consider, at least in this first round, to not grant more than 1, 2 max dispensary licenses to an individual applicant entity. What that does is allows for a larger social laboratory for more variations of this business to emerge, and then in the renewal process we can start skimming the cream from the top. I think if we have a smaller number of owners, that really works against the best interests of the people, of the state. So I hope we move in that direction. As far as the federal government goes, I think it's safe to say that whatever directions we're hearing very promising things from Senate Judiciary now, but this session of Congress, at least up until the next set of elections in 2014, they're not getting anything done. We can see the shutdown now, the gridlock that's going on. There is no realistic possibility that the federal government is going to change its policies before the implementation of this law. And I know people talk about it, they should do this and they should do that, but in reality, nothing's going to happen before the 2015 Congress at the very earliest. So we can't count on that, and we really, as an emerging industry and as a regulatory body, need to just look at it as it is now and say, this is it for the foreseeable future. We've seen some promising movement from the Department of Justice in the past couple of months, but really it's no more substantial than a piece of paper right now, so we can't really go there. And the last point I'd like to bring up is a clarification. I think I read this correctly, but I get a lot of questions from people who are now saying, I want to be in this. I want to work in this industry. I want to own this industry. So I'm rushing out to get my medical marijuana card right now. There's nothing in the legislation that I see that requires anyone who is either investing in, operating, or working at any of these facilities that they necessarily have to be a medical marijuana patient in the state. And so that's what I've been telling people. But if I'm wrong, I'd like you to correct me on that, and I'd like you to just clarify that so it's out there in the public. And once again, thanks for your patience. We appreciate all your hard work and look forward to working with you in the future. And I'm on the board of directors of We Can, so our organization stands ready to assist in any way we can. Thank you.
Thank you very much. I agree with you. There is nothing in the law that says that you have to be a patient to have any ownership in any of the establishments. So that would just be incorrect information that people might have. And I appreciate all your other comments. I don't think I have anything else to respond to.
I have a
Thank
question
you.
for you, Marla. So if you're working in a dispensary, do you have to be a patient?
No, there's no requirement in the law that would require you to be a patient to work in a facility. We do have the criminal background check provisions that are still in place, so it's likely that if that would be one of the primary limiters for anybody working in a facility right now, or out into the future anyway. If we could remember to mute your phone, and if you need to take a call to disconnect the line and come back in, we're getting some feedback from the phone. Go ahead, Mr. Gale.
Thank you very much, Marla. I'll try to be very brief. I want to talk real briefly about line 2, section 3, requiring a consulting physician, and some of the comments earlier, and really regarding the potential role of the consulting physician. I guess I have a real problem if a consulting physician of a medical marijuana establishment basically giving medical advice to a patient who's coming in regarding the appropriate strain and dosage of marijuana. The patient presumably has received a registry card appropriately because it was properly issued by the state, and there was the valid appropriate documentation from his attending physician that it was appropriate. And if I'm representing a dispensary and theoretically or hypothetically a patient is not satisfied, I won't say has an adverse reaction, but the particular strain or dosage that the consulting physician or someone at the dispensary recommended to the patient doesn't work, I don't want to potentially open up a potential lawsuit and liability to every patient who came in and received some marijuana at the dispensary. So I'm concerned about that. Secondly, regarding, and I talked about this earlier, regarding line 63, and I guess I was incorrect. I didn't have NRS Chapter 453 in front of me, 453A, and there is a definition of marijuana, and there is a definition of usable marijuana. There's also a definition of medical use of marijuana, but there's not a definition of medical marijuana, and that is referred to in item 63. And that's it. Thank you very much.
Thank you. Next.
Okay. Line 71. We'll start there, keeping it in that form. Specifics specifies the labeling responsibilities of the dispensary. When I opened the dispensary in AZ, it was a very simple process. I invited the anti-trafficking, anti-narcotics task force in, plus the PD, and their biggest concern was how do we differentiate between patients that acquired this medicine at a dispensary and dude who bought it on the street. And they had no answer for that, so I held a simple, not a seminar, just explained to them. I said, okay, look, when we dispense a bottle or we dispense any container with medical cannabis in it, it's going to have the patient ID, it's going to have the dispensary ID, it's going to have that strain, which I'll touch on in a second, and it should have some abbreviated form of chemical content and justifying the purity with the lab aspect. So very simple process. That way, somebody gets pulled over. I have medical cannabis on me. Oh, can I see it? Boom, boom. They see their card. They see their bottle. It's right there. It's very simple to get line 71. And then another item, I'd say if everybody could stop stressing the state officials out by saying, I'm going to go get strains from California, I'm going to bring this in. That is interstate trafficking for everybody. So it will get here. There's no need to bring it up. In Arizona, they've dubbed the term original stock. That's, you're bringing up, I'm going to go traffic cannabis, an illegal substance from another state. We can just cut that out and I'll never bring it up again. But, so, and then the other point was, a gentleman brought up crowdsourcing. That's being done. I mean, between Weed Maps, THC Finder, everything online, that is, it's not really going nowhere. Patients telling each other, you can go on any message forum board and understand that patients are out there talking to each other big time. It's to slow down. It's not a matter of strain. I mean, I have 10 different blue dreams. I mean, I have Joe's blue dream. I got my blue dream. It's a matter of cuttings and that specific chemical content of the grower. I mean, the strain name is so relevant at this point, from $100 OG to Blue Dream. I mean, there's so many different things, and there's 10 different varieties of that one strain. So when you're applying a lab to a dispensary, it would come down to a proper classification if you really wanted to up the ante on the entire medical cannabis program. Because to say for a patient to still come in, and not to dismiss the name, they're always going to be there, but okay, $100 OG, this is line item -17-1 from this cultivation site that is from this specific cutting from this breeder. Okay, we can actually look it up and go find it. That's a huge one right there. And then to touch on another point somebody brought up, shelf life. That's semi-irrelevant. If you actually have to store your meds for that long, you got a problem. So you don't need a nitrogen packet. I mean, if you're growing that amount, why are you storing it? They should be in the patient's hands pretty quickly. I've never stored anything. The key to the board to build for Nevada is diversified. Oh shit, that's mine. Sorry. Apologize. Good timing, huh? But anyway, every state. I mean, we operate 2 pre-ICO shops in California for the last 8 years. So every time I go to a new medical cannabis state, it's always, everybody that's upstanding citizens and business people of that society. There's no cannabis-related people because they don't exist. I mean, it's hard to find them. They're pretty much far and few between. So some kind of diversified board's cool. That'd be helpful. The gentleman that brought up the point of selling it to yourself from your own cultivation site. This industry is all about vertical integration. It really is. That's pretty much a no-brainer right there. You're going to get it from your own cultivation site. That's the model that everybody's after all the time. And pertaining to people coming from out of state into Nevada, I would state that the ancillary industries that circle around cannabis in general are where the money's made. People are going to come in, doesn't matter where they're from. They're going to come in, they're going to get real estate, they're going to buy cars, they're going to get houses, they're going to get commercial real estate, they're going to do all this stuff, they're going to go to bars, they're going to go to hotels. Whether they come from California, Michigan, Florida, they're going to spend money in Nevada. It's going to be, whether you're a Nevadan or you come from anywhere else, the ancillary aspect of it is monstrous. That's where the money's made. That's what's going to bring up the economy. To get to that point, the next one would be the guy who said that I can get a 100,000 square foot cultivation site and dominate the market. You're never going to dominate the market. Let's just put it that way. So it's impossible. You can have 500,000 square feet. I mean, we got a 25,000 square footer and we're not even touching the surface. So that's pretty much all I had. Line 71 was big because the police department really appreciated that. So actual on the agenda. So thank you.
Thank you.
Hey, Marla,
Next.
good morning. Steve Cottrell calling from AZ Med Testing. Can you look into some definitions and defining much more clearly the use of concentrates? And as to, are concentrates going to be allowed for patients to use, or are concentrates only going to be allowed for infusion of edible products? That's a very a sticky subject here in Arizona currently, and if you have adopted Arizona's laws, let's get you guys clear of any potential headaches in the future, because it's a big headache here.
Okay, we'll take that into consideration. I'd like to come back here to Las Vegas, please. Go ahead.
I'd like to make a few comments. The state already has a tracking system in place, Jennifer Solis. The state already has a tracking system in place for doctors that identifies the doctor who's prescribed. I think there are over 437 in the state of Nevada. It tracks the age of the person who's getting the card, the qualifying condition, and it's accessible through the Division of Health and Human Services to everyone. The other thing that I'd like to talk about is that the concentrates are absolutely necessary for cancer patients and for people that have devastating medical conditions. The concentrates are what help heal people from cancer and from very serious conditions. One other point I'd like to make is that continuing education every year for people that work in the industry is absolutely necessary. In the medical field, we have continuing education that we have to get so many hours live in front of a person and any other means that we can yearly to renew our licenses. And that continuing education allows for educational jumps in the industry so that everybody can be well informed. Thank you.
Thank you. Next.
Hi, Vicki Higgins. I agree with Jennifer wholeheartedly on the continuing education. A couple of quick points. The gentleman who was concerned about 2 people on a delivery. How do pharmacies deliver? I am totally unaware. I'm wondering if maybe we might want to base it on that program. But I do feel that 2 people in the vehicle is important. In the labeling process, I think preservatives also need to be tested and included, being that we're considering edibles. The language, as we go through the different establishments, if we hopefully go with this quality control sealing stamping program, that it needs to be redundant in each of the language of all the different establishments as we've got it throughout the bill. Something nobody has talked about is the taxes. As a dispensary model, we are not allowed any deductions. My understanding is the only deductions for the growers and the cultivators are going to be water and power. Now, we're operating as small businesses, producing a lot of jobs and stuff for...
Ms. Higgins, before you go into too much detail on that, it's not part of our regulation set.
Okay.
So I'd be happy to talk offline with you if there's someone else we could connect to on that piece.
Certainly, no problem.
Okay.
Thank you very much.
Thank you. Go ahead, please.
Marla, good morning. Scott Lopez here again. One thing I just wanted to bring out is on line 2, consulting physicians, and I know you asked us to do it by email, but just real quickly, I do not believe Walgreens or CVS require a consulting physician in those facilities. Now, from here, I'm going to go get a flu shot, which they offer, and they make you fill out a small little application form. I think it needs to be taken out. I don't believe we need that. It's just another added expense which will be passed on to the end consumer. The other thing is the answer to the young lady's question as far as how do pharmacies deliver. When I do a 90-day order on my prescriptions, I get them delivered right to my front door by UPS, and I have to sign for them. And some of them, I'm a heart patient, so some of those medications are pretty strong. And I don't think it's necessary to have, an armed guard or 2 people in a van to do a delivery. I'm sure that, and maybe the folks from Arizona may have a little bit more insight into this, but how much of that is really going to truly be delivered to a patient? Now, maybe delivery from supplier to dispensary needs to be a little bit clearer on that. Maybe I'm wrong.
Thank you.
You're welcome.
Can you push that button, please? Go ahead.
Thank you very much. My name is Paul Cody. 20 plus years medical marijuana experience. Real quick, I just wanted to say a couple of things need to be very strictly dealt with. is the patient identification system. If you don't have an identification system put up when your stores are open, you can kind of see a problem. I've come from a background where I've been in an office working fax machines and had 20 plus patients waiting to get their medicines. The importance is extreme to have a functioning system in place as soon as possible that is unified. You're talking about perhaps visitors coming out of state for a day or two. The system has to be up and running imperatively as quick as possible. On the other hand, with the medicine identification, bud tending classes, and such, I think there's a wonderful group out here. I lived in Las Vegas for 3 years now. I've come to love it and absolutely just think highly of the people here. I really think that a group like We can go ahead and assist with a formal setting of a classroom structure that would suffice for bud and medicine identification education classes. That's very important to have bud tenders, owners, managers that actually understand a little more than the shape of a leaf or several different kinds of people's names on strains. I love the old adage that Betty Crocker kind of threw in, is that she said something along the lines that you can give the same recipe to make a cake to 10 different chefs and end up with 10 different cakes. So I think what's happening here, I applaud Nevada for taking the standards that are occurring right now, and I'm looking forward to participating in as many meetings as possible. So thank you very much for your time.
Thank you. Anybody else here in Las Vegas?
Ralph Wenger, Paradise, Nevada. Very quickly, I just want to touch on a couple things that haven't been mentioned, and I'd like to make note for everyone here that the purpose of us sitting here right now is to give our opinions to this board so that they can implement those opinions into the final decision-making process. So as the rest of us continue reading these 87 pages of regulation, please send a email to the listserver or this group to get your opinion implemented on here. I'd like to show my thanks for being a Nevadan, where we tend to streamline things and get right to the point, where we avoid a number of the additional regulatory aspects of a program, and we focus on the meat and potatoes of it. My best example would be the use of an affidavit form to make sure that this program, the patient verification system, is enacted, and we have something along the mention of that form in place, instead of diving into a multi-million-dollar patient verification system. That we could watch some of those other markets as they develop, and those patient verification systems become available more on a national level than us trying to operate from here to other states. I'd like to make a couple of other opinions that I want to share with you. There is, in the application process at the end, and I know this is tomorrow, but there's a comment that reapplication with change of address would fall into the big pot, and I would like to move that to giving preferential treatment for those that do open up their businesses and need to move, either because of space requirements or whatever it would mean that they would have to relocate their business, but they would be given an opportunity to continue their business as opposed to going into the melting pot or the decision pot of any and all new applicants. I'd also like to suggest that we keep our industry workers permits very reasonably priced and easy to get, doing that through education, through dispensary, or through medical marijuana medical marijuana establishments. If we can keep our education through there or through the existing foundations that will support us, we could use a program very much like our existing sheriff's card or TAM card program to register our people. I do see, as a business owner and a retailer, I see a lot of turnover in new hires and new starts. And in order for us to keep the very best people, to be able to service our patients, we'd like to be able to turn those people over pretty quickly. There are a couple other things that I'll address, but I want to do that through email to you, and I thank you very much for having me today.
Thank you very much. Anybody else here in Las Vegas? Can we go back up to Carson City? Anybody in Carson City? Anybody on the phone feels like they need to weigh in before we close up? Okay, again, thank you, everybody. Your input is really going to help us make sure that we're doing the best job we can for everybody. I did want to, as we indicated, tomorrow is discussion of applications. We're currently working on our handout. Hope to be able to release that before the end of the day. It will be released on the listserv. We will have copies available at both sites, but look for that hopefully before 5 o'clock. And if we could tomorrow be prepared to discuss that, and we'll keep moving forward. Thank you, everybody. And no other comment. We are adjourned for the day. Thank you.